It is indeed a privilege and a pleasure for me to introduce one of my colleagues from Houston, Texas, Judge Gregg Costa. Gregg was one of our co-chairs in our region down in Houston on the White Collar Committee and was very, very active in the ABA prior to his appointment to the bench. His rise in judicial ranks has been swift. Back in September of 2011, he was nominated by President Obama to be the sitting judge in Galveston, Texas. There's only one judge in Galveston, and that would be the appointment of Gregg to the United States District Court. He could not take the bench immediately because he was preparing for the Stanford case. That is the trial in which he's going to be talking to you about today. He was getting ready for trial. Mr. Stanford was ultimately convicted in March of 2012, and the very next month, Gregg was appointed and confirmed to the bench. He got rave reviews, and the president took notice, and a scant year and a half later, he was nominated to the Fifth Circuit Court of Appeals and was confirmed in May of 2014. Taking a look at Gregg's background, immediately you understand why he became a judge as quickly as he has and elevated as quickly as he has. Upon graduating from Dartmouth, he taught elementary school in Sunflower, Mississippi with Teach for America. He did that for 2 years. Upon conclusion of teaching, he went to the University of Texas, where ultimately he became the editor-in-chief of the Law Review. Upon graduation, he went to Washington, D.C. and clerked for Judge Raymond Randolph, United States Court of Appeals for the D.C. Circuit. If that clerkship wasn't enough, he went on to clerk for Chief Justice William Rehnquist of the United States Supreme Court. Upon conclusion of that particular clerkship, he returned home to Houston, where he joined the law firm of Weil Gotshal. But Gregg, wanting trial experience, ultimately joined the United States Attorney's Office for the Southern District of Texas and was an AUSA dealing in primarily fraud cases, where he was for 7 years. It culminated in the conviction of Mr. Stanford in a $7.2 billion Ponzi scheme, where Gregg received the award from the Assistant Attorney General of the Department of Justice for exceptional service. In 2013, he received the Marshall Award for performance in prosecution of white-collar crime. Since taking the bench on the Fifth Circuit, as if that wasn't enough, Gregg has kept his docket that he had in Galveston, Texas. He believed that he had a commitment to the people of Galveston. Galveston is a community approximately 45 minutes or so outside of Houston, but they're only having one judge. Gregg has kept his docket. He has kept 200 civil cases and approximately 60 criminal cases that he will see to the end. In fact, a few weeks ago, he tried a patent infringement case that lasted about 2 weeks. He is exactly the type of jurist that we can all be proud of. He's committed, he's dedicated, he's hardworking, he's a trial lawyer, he understands what goes into trials, he's committed, and he's a heck of a nice guy. And with that, I give you the Honorable Gregg Costa.
Thanks, Phil, for the kind introduction. Having the morning speaking spot at a conference in New Orleans isn't always ideal, but hopefully a lot of you enjoyed the city last night. It's really a great city that I've come to know even better since I've been appointed to the Circuit Court last year. And of course, our court is based here. In fact, if any of you haven't ever argued in the Fifth Circuit, it's really just a few blocks away, and it's a beautiful building that's celebrating its 100th anniversary this year. It's named for Judge John Minor Wisdom, who's one of the true judicial heroes of the civil rights era. So I'd recommend going to check out the beautiful courthouse. And it's great to see a number of friends, people I prosecuted cases with, people I prosecuted cases against during my time as an AUSA. And I've been at this conference before. I know it's a great event where everyone comes together to learn about new developments in the law of white-collar enforcement. And over the next couple days, you're going to hear about how judicial decisions over the past year, new enforcement priorities, new laws have affected areas like insider trading, corruption in practice, and various other areas. And especially those of you who've been coming to this conference over the years, you've seen how drastically the legal landscape has changed surrounding white-collar enforcement. But the actual fraud itself that gets investigated doesn't change quite as much as the law does. I mean, sure, the dollars amounts get bigger, the fraud is more global in scope, new technologies are used, but the basic modus operandi of different schemes doesn't change all that much. And I came to this realization when I was prosecuting the Allen Stanford case, which Phil mentioned. And if those of you who followed that case may know, there were some lulls in the action. It took a while to get the case to trial. And during one of those slow periods, I read a book about the original Ponzi schemer, Charles Ponzi. It's a great book, actually. It's called Ponzi's Scheme by Mitch Zuckoff. And I was reading the book, chapter after chapter. I was struck by how similar the means were that they were using to commit their fraud. But then I got to the end of the book, and after seeing how similar their schemes were, once Ponzi had been exposed and entered the legal system, and I was struck by how different his treatment was in the legal system. So I thought I'd talk this morning about how their fraud schemes were so similar and yet how the legal system treated them so differently. And it wasn't until I put this PowerPoint together that I realized actually one similarity is they kind of look alike. Now you can't tell from the photos, Stanford's about a whole foot taller, he's 6'4", than Charles Ponzi was. But maybe there's something about mustaches. Anyway, in terms of the fraud schemes being similar, they both had claims of plausibility. For those of you who don't know about Ponzi's scheme, it was a scheme involving what were known as international postal coupons. So the idea was if you were over in Italy sending a letter to your family in the United States, you'd go to the post office in Rome and you could buy a postal coupon for the price of an Italian stamp. And you could include it in the letter you were sending to your American relative. And when they received it, they could exchange that coupon for an American stamp to put on the letter to send back to you. Well, what happened is after World War I, when there was hyperinflation in Europe, there was big variations in the exchange rates. So there truly was an arbitrage opportunity in these postal coupons. So there was, at a basic level, there was something to Ponzi's idea. The problem was you needed about 150 million of these postal coupons to generate the profits he ended up needing to pay back his investors. And in actuality, there were only about 20,000 in existence throughout the world. But again, there was a basic plausibility to his scheme. Stanford, the same thing. He talked about international money managers, diversified investments, the tax breaks of being located in the Caribbean. And one of his early employees testified at trial that Stanford always said the magic number was 2%. If he could provide rates 2% above what U.S. banks were paying on CDs, that would get people to invest. And much higher than that, and it would be too implausible. So both had this surface plausibility. Both, of course, needed to expand their investor base. That's the heart of a Ponzi scheme. They needed to keep more money coming in. Stanford, the first 10 years of his bank, didn't sell the CDs in the U.S. because he wanted to avoid U.S. regulation. But eventually, the need to expand the base overrode that concern, and he started a U.S. brokerage firm. And what he did, he brought over brokers with existing clients from places like Merrill Lynch, who would then get their clients to invest in his CDs. And Ponzi, who basically preyed on the immigrant communities in Boston, hired sales agents from those communities, advertised throughout Boston. They both, to get that legitimacy you need, they both bought businesses that seem legitimate. Ponzi bought a Boston bank called the Hanover Trust. Stanford bought various businesses, none of which really made any money, but they lent to the plausibility and the legitimacy he needed. They also obviously needed to keep people from withdrawing their money. So Ponzi gave higher interest rates to those, or higher returns to those who would keep their money in for the long term. And Stanford incentivized his brokers to keep people from withdrawing their money by having trailing commissions. Other similarities, they tended to hire for the top positions inexperienced, loyal people who would have no better options out in the workplace. Ponzi's only employee was an 18-year-old named Lucy Melly, who became his bookkeeper. No experience in the financial world. Alan Stanford hired his old Baylor roommate, Jim Davis, who'd been an accountant for a retail store. Good, solid job, but not the kind of job that usually leads you to being the CFO of a billion-dollar company. Of course, keeping the book secret was also important to both of them. Ponzi kept all his records on just note cards. Stanford, a key part of his scheme was bribing Leroy King, who's pictured there, who was the head of regulation for banks in Antigua. And Stanford also had an outside auditor who he was paying through a Swiss bank account, and over the years looked the other way and didn't actually audit the books. One of the more, I thought, compelling pieces of testimony at trial was on New Year's Day 2009, this outside auditor, Mr. Hewlett, passed away. And this is within 6 weeks of the SEC shutting down Stanford. And so he knew the writing was on the wall. And when Stanford learned that the outside auditor had died, his comment was, well, he was the lucky one, because Stanford saw the writing on the wall. They both had trappings of wealth, again, to lend the legitimacy. This is Ponzi's mansion outside of Boston, which had a swimming pool and air conditioning, which in 1920 in Boston, both of those things were rather unique. Stanford, of course, was on the Forbes list of richest Americans, had a fleet of jets, an armada of boats. His offices he modeled after 19th century British banks, and he actually put real 14-karat gold, flakes of gold, in the marble floors. Both tried to exaggerate their family's background. Ponzi claimed that he was descended from Italian royalty. Stanford claimed he was in the same family as Leland Stanford, which led to Stanford University suing him. And Stanford also claimed that his financial services company dated back to the 1930s, and that his grandfather, Lotus Stanford, started the company during the Depression. Well, one of the people in his PR department who had been promoting this over the years said, you know what, I'm actually going to go do some research. This is great. I'm going to talk to people who might have known Lotus Stanford. And so he went to the small town Stanford was from. It's about 2 hours north of Houston. And he asked people around town about Lotus Stanford. And someone said, oh, yeah, I knew him. He was a barber. And the Stanford employee said, oh, but didn't he do some financial investments? And the people who knew Lotus said, well, I mean, he was a loan shark every now and then. So they both, again, had tried to exaggerate their family history. They both also had questionable past that they went to great efforts to hide for obvious reasons. Ponzi had actually been involved in a bank scandal in Montreal. He'd also been charged with alien smuggling. Stanford owned some gyms in the 1980s that went bankrupt. And his bank originally started not in Antigua, but in an even smaller Caribbean island called Montserrat. And around 1990, his bank was kicked off the island for a number of reasons, not having an authorized auditor, the fact that they found out about Stanford's bankruptcy, and a bank director can't have a history of bankruptcy. Stanford obviously went to a great deal of effort to hide that expulsion from Montserrat. And at first he said they left Montserrat because of a hurricane, but over time that changed into a volcano being the reason. So again, just more of the common threads between these two schemes. And they both, like I think all Ponzi schemers, thought there was a way out, a lottery ticket that would solve their problem of owing so much more than they actually had. Ponzi was going to form a new conglomerate. Very similarly, Stanford said he was going to consolidate all his businesses, and all the massive losses would somehow turn into profits. And there you can see people lined up outside both of their banks after the fraud was revealed. But then when they went into the legal system, their experiences changed quite a bit. And Ponzi had far fewer procedural protections than Stanford did. For one thing, Ponzi went to trial in just 3 months. Stanford had 30 months to prepare. Ponzi represented himself pro se. Now, interestingly enough, he fared pretty well. I don't know what that says about the quality of lawyers, but Ponzi, representing himself pro se, actually won his first trial in the state against the state and got a hung jury the second time against the state. It was only the third time that the state was able to convict him. And also, today, he probably would have had a good argument that the first acquittal would have been given double jeopardy grounds for dismissing the rest of the case based on other victims. But at the time, there was no basis for doing that, so he gets convicted the third time. Stanford obviously gets counsel after his insurance money ran out. He had government-appointed counsel, and I think it's probably the most expensive government-funded defense in the history of the Fifth Circuit, at least. Asset forfeiture. I know this is a controversial area today. There's a lot of talk that the law in this area too strongly favors the government, but Ponzi's assets were frozen without there even being a court order. At least in Stanford's case, through the SEC filing, there was a court order in the civil proceeding, and Stanford had the right to challenge that in the civil proceeding. Federal versus state involvement. The state was much more involved in Ponzi's prosecution. And what actually happened, Ponzi pled guilty to a federal charge, was sentenced to only 5 years, and there was a huge outcry which led the state to prosecuting him and those 3 trials I talked about. And then, despite the fact that Stanford had all these much greater procedural protections, his sentence is quite a bit stiffer. As I said, Ponzi got only 5 years in the federal system, 7 years on the state charges, and then Stanford gets a 110-year sentence. Interestingly, Ponzi fled Massachusetts and didn't serve his state prison term. Went to Florida during the real estate boom in the 20s and was convicted of real estate fraud. So he had an interesting past even after his scheme was uncovered. So these two themes of greater procedural protections in our day, but actually much stiffer penalties, it's actually part of a broader commentary some people have made on our current legal system. There's a book by a Harvard professor, William Stuntz, that came out a few years ago called The Collapse of American Criminal Justice. And he argues that all the procedural rights that defendants now have through the Warren Court revolution have paradoxically actually hurt defendants in many ways. Because we now have these statutes, the reaction has been to have these statutes that are read so broadly and criminalize a great deal of conduct, and then the consequences of getting convicted have grown much greater. So again, that argument is too much for me to go into in detail here this morning. But I think that theme and looking at the comparison between what happened to Stanford and Ponzi in the legal system, it may provide a lens over the next few days as you're listening to all these developments in the area of white-collar enforcement, to think about whether these changes in the law are actually leading to a system that provides a better deterrent and that provides a more efficient and fair system for both victims and defendants. So enjoy the conference, enjoy the city, and thank you for having me.